Okay, welcome everyone. My name is Meghan Leemon and my colleague Lauren Brier is also joining us as well. We are going to be talking about the request for equitable adjustment claim and appeal process. Thank you for joining us today. Please note that Lauren and I are in two separate locations, so we don't anticipate any technical difficulties, but if we run into anything, we'll try to correct it as soon as possible. So just a little bit of background about our firm. We are a business law firm which specializes in government contracts. We are recognized really as bread and butter. Government contracting is our bread and butter, but we have a lot of experience with over multiple practice areas. We have a very robust corporate group, employment group, litigation group as well. And if you don't already subscribe to our newsletters and blog, we highly recommend that you do so. We do send a lot of information and advice out on a weekly, sometimes daily basis. Again, my name is Meghan Leemon. I'm an associate with the firm. I work out of our Colorado office. I work on a lot of government contracting matters, including REAs, claims, and appeals.
And my name is Lauren Brier. I'm an associate attorney with PilieroMazza, and I represent commercial businesses in a variety of government contracting and litigation matters, more specifically debarment, suspension proceedings, REAs, claims, multiple award schedule contracts.
So today we are going to be talking about REAs and claims somewhat at a high level, but kind of give you some tips and tricks for whether you should file an REA, a claim, things to consider before you file, items that need to be included in such. We're also going to be talking about subcontractor claims, which are a little different because subcontractors do not have what's called privity of contract with the government. So if you are a prime contractor, you have to sponsor their claims. And then we're also going to be touching on an overview of the claims appeal process. So if you submit a claim and it's denied, what do you do after that? So the biggest question we get when clients approach us with a potential issue with a contract where they need either additional time or money or both is, what do I do? Do I file an REA? Do I file a claim? I've heard these terms, but I don't know exactly what they mean. So the biggest difference between an REA and a claim is that a claim is a formal claim with the contracting officer. An REA, a request for equitable adjustment, there is no official definition. But generally, for both, you're seeking a request for either time, money, or both. For an REA, it's typically filed as part of when the contract is ongoing and during performance. An REA, request for equitable adjustment, really it's a relief in equity. It's a relief in fairness. You're asking the government to work with you when there's been some change or issue that you've encountered such that you should be entitled to additional time or money or both. It definitely falls short of a claim in both procedural requirements and formality. There is no specific format that's required. It's relatively informal. Whereas a claim, you're submitting a written demand seeking the payment of money in a sum certain. So you have to submit the specific amount that you're requesting and provide documentation to support such. If you're not requesting time or money, or you may just be requesting an adjustment interpretation of the contract terms, you can also include that in a claim. Or some other relief relating to and arising out of the contract. A claim is filed under the Contracts Disputes Act, which is it's a formal dispute, and if it's not resolved at the claim level, it may lead to litigation through the appeals process. Some basics for an REA is that an REA should generally be submitted anytime during contract performance or closeout, but it may not be submitted after the contract has been closed out. So if you're performing and there's an issue that arises, generally you just submit the REA roughly within 30 days of the change that gave rise to the REA. This isn't a hard and fast rule, and you're not necessarily going to be barred if you do not follow the 30-day deadline, unless the government can show that it was prejudiced by the failure to submit the REA within that 30-day time. And that generally means if the government says, had you submitted this REA earlier, we would have done something differently, or we would have saved money, or something along those lines. Generally, the rule of thumb is to submit it within 30 days. Not an absolute, but it is a good rule to adhere to. As I mentioned earlier, there is no particular format that is required. It does typically just take the form of a letter to the contracting officer explaining the basis for the REA, complete with exhibits. The best thing to consider is really, you should prepare it as if you were submitting a claim with that level of detail. Not that there's necessarily a dispute, but it should be detailed enough to provide the agency with sufficient information regarding the basis and the amount that you're seeking, and or time and or money. You should include the details, including, what was the basis for this REA? Direct costs, markups, time to complete. Again, it should be just as detailed as you possibly can make it. At least outside of the DoD context, there's no certification requirement, and I'll touch on the certification requirement for DoD REAs in a later slide. And one of the other biggest pieces to consider for an REA is that preparatory costs, including attorney's fees, admin costs, and your own internal costs, the time that you spent preparing this REA, are recoverable as part of the REA. However, these fees, the REA should not be presented as a dispute. You're not in a dispute yet. It's a negotiation with the government. You're working with them such that you can include the attorney's fees, costs, in your internal costs. When it becomes a dispute, you're no longer able to include those costs. So if you're still working with the agency throughout contract performance, they say, yeah, we recognize that there's a change, just submit us an REA for that. You would just submit the REA. You can include attorney's fees and your internal costs to submit the REA. However, if the agency has come to you and says, we're not paying this for you, you now know that you're in what's a dispute, such that you may want to consider filing a claim.
So moving to some claim basics, as Megan has indicated, there are distinct differences between an REA and a claim. The rate for a contractor to file a claim is recognized under the CDA, which can be found at 41 USC section 7101. And in accordance with the CDA, a contractor may, within 6 years from the date of accrual, assert any claim as against the government to the CO or contracting officer for consideration. Federal Acquisition Regulation 52.233-1 incorporates the requirements of the CDA into contracts. And a claim is defined under the CDA as a written demand or written assertion by one of the contracting parties seeking, as a matter of right, the payment of money in a sum certain, the adjustment or interpretation of contract terms, or other relief arising under or relating to the contract. So same goes for claims as REAs, that there's no particular format required when filing a claim with the CO as defined under the CDA. The claim just needs to constitute a clear and unequivocal written statement that gives the CO adequate notice of the basis for your claim or the amount sought. We often recommend to our clients that a claim include all relevant documents and correspondence that support the claim. Mostly because the more detail you have in an REA or in a claim, to ensure jurisdiction, if you end up appealing the claim, you're bound to the information that's actually cited in the claim itself. You can't bring any additional information, technically, because it wasn't before the contracting officer. After the contractor submits the claim, the contracting officer must either resolve the claim within 60 days from receipt, and that's for claims under $100,000, or the CO has to notify the contractor of the date by which the CO will issue the decision. The contracting officer is required to issue a written final decision in response to a submitted claim. Another thing that is important to note on claims, unlike REAs, a preparation and attorney fees in preparing the claim are not recoverable.
So as I mentioned previously, REAs generally do not need to be certified. The exception is for DoD contracts when the value of the REA exceeds the simplified acquisition threshold. When that occurs, the REA must include a certification stating that the request is made in good faith and that the supporting data that's being provided is accurate and complete to the best of your knowledge. Additionally, an REA is typically submitted prior to there being a dispute and when there's a negotiation. And if the REA exceeds 100,000, which is the threshold for the certification requirement under the CDA for a claim, it may be converted into a claim by complying with the claim certification language that Lauren will discuss in the next slide.
So when submitting a claim, if you're seeking damages, a contractor is required to request a sum certain in the claim. So when a claim made against the government exceeds $100,000, the contractor must certify that the claim is made in good faith and that it is accurate to the best of the contractor's knowledge and belief. And this specific language for certification for a claim is set out in FAR 52.233-1 D23, and the certification under this FAR clause must specifically state 1, that the request is made in good faith, 2, that supporting data is accurate and complete to the best of the submitter's knowledge, 3, that the amount requested accurately reflects the contract adjustment for which the submitter believes the government is liable, and 4, that the submitter is duly authorized to certify the claim on behalf of the contractor. And as far as authorization goes, normally it's the president or CEO of the company that is executing the certification to incorporate into the claim.
Next, we're going to talk about, we've kind of already alluded to some of this, but whether you should file an REA or a claim. As I mentioned previously, the biggest distinguisher between the two is where you're at with the government in the process. If an REA really is a negotiated resolution and kind of an open discussion with the agency and the government. Typically, an REA is submitted when the government has indicated a willingness to reach some type of resolution, or where they're willing to work with you and negotiate in good faith to some type of resolution. If you do not have a good working relationship with the government, or when the government has already told you we are not going to pay you for the adjustment that you're seeking and or add additional time to the contract, and such that there's a clear indication that there's some type of dispute, then a claim would be the appropriate method to go. Again, the key factor is whether the item is in dispute or not. You also should understand what you can pursue through an REA or a claim. You're often entitled to uncover your actual costs as well as additional time, and you may be able to recover reasonable profit, except for suspensions, as well as overhead and G&A and bond costs, particularly for construction contracts. This is a sample list. It's not an exhaustive list of certain arguments and issues that you can pursue via an REA or a claim. We are going to discuss in detail a few of these, but we did want to just give you a list of kind of the most common items that are sought through an REA or a claim, including delays, variation estimated quantity. We're not going to get into that specifically, but generally the rule is when there's been a 15% change over the estimated, more than 50% change over the estimated quantity, you would be entitled to some type of adjustment. The reverse of that is also true if it's less than 15% difference. The government could actually see that the cost of your contract could be reduced. One of the other items is changing to prevailing wages. There are price adjustments under the Service Contract Act, and those have specific rules, whether there's a wage determination and/or CBA included into your contract. If there's changes to those while your contract is ongoing, that's something that you may be able to recover. Differing site conditions, suspension of work, changes, stop work order, terminations, and CPAR is one that we're seeing used more frequently. If you have a CPAR, you submit your comments, the rating isn't changed and it goes final, you are able to submit a claim regarding those ratings to try to have those revised.
So the clients most often come to us with delay claims. Under the standard FAR delay clauses, contractors can be excused for delays that affect the contractor's ability to timely perform, so long as the delay is beyond the control and not due to the fault or negligence of the contractor. An excusable delay, which would be recoverable to extend the time of performance, it has to be unforeseeable and arise from things such as acts of the government, or another example would be unusually severe weather. Moreover, the delay must be to the critical path of performance, as it has a direct impact on a contractor's ability to complete in the period called for by the contract. So when a contractor comes to us and is able to demonstrate excusable delay, it is then entitled, as I said, to an extension of time, but not an increase in cost. In order to get cost recovery, the delay has to be the fault of the government, and then a contractor can be entitled to compensation. Most common types of delay claims that we handle are where the government does something during performance that interferes with production. For example, it prevents the contractor to access the base, to perform certain construction. Cost increases will then result from that delay due to their lack of base access. Another example is, say the contract says you can work 24 hours a day on a project and you can excavate around the clock, and then the government comes back and says, no, we're going to actually limit the amount of hours that you're able to work, which has a significant impact on project performance. Costs would then be incurred and would likely be recoverable in a claim. Another common claim argument that we raise are differing site conditions. So the FAR permits contractors to recover damages associated with unanticipated physical conditions that exist at a site where work is performed. There are two different types of differing site conditions that can be argued. The first category covers subsurface or latent physical conditions at the site, which differ materially indicated in the contract. And then category 2, that covers unknown physical conditions at the site that are of an unusual nature and which differ materially from those ordinarily encountered and generally recognized on the particular type of work in the particular locality. So in order for a contractor to recover on a category 1, there are certain elements that are applied by the boards as well as the Court of Federal Claims. These specific elements for a type 1, category 1 differing site condition the first element would be that the contract must affirmatively represent the subsurface conditions. Element 2 would be that the contractor's interpretation of the contract documents must be reasonable. Element 3 would be that the contractor must reasonably rely on the contract's indications of those subsurface conditions. Element 4, there must be a material difference between what's indicated and encountered. And then element 5 would be the actual subsurface conditions must be reasonably unforeseeable. For a category 2 differing site condition, the elements are a little bit more limited. It requires that a contractor demonstrate, 1, that the condition was unknown to the contractor, 2, that the condition was unusual, and 3, that it materially differed from conditions that would be expected. Regardless of the type of differing site condition claimed, the condition that is observed at the site, it has to predate the contract and must not have been discoverable during a site inspection. So if you're performing a site inspection, you want to make sure that it's thorough, but you also want to make sure that you have a tight record of what was conducted, so you can go back and demonstrate that, you know, the condition that was eventually identified was not plausible to be identified at the site inspection. Okay, so moving into terminations, there are 2 types of terminations that the government can implement. One is a termination for default, and one is a termination for convenience. So terminations for default occur when a contractor fails to perform as required by the contract. The government can then exercise its right to terminate the contract for default. So sometimes our clients experience that prior to receiving a T for D, the government will often issue them a cure notice instructing them to remedy the default condition within a specified period of time. Oftentimes our client will issue a response letter to that cure notice and try to perform, but ultimately they'll face termination of the contract. The government, once they do issue that termination for default notice, if it is challengeable and a contractor decides to challenge it, the burden is actually on the government to demonstrate that its default termination of the contractor was justified. So contractors can and usually do challenge the government's basis for a default termination. A termination for default constitutes a contracting officer's final decision. So in order to challenge it, instead of filing a claim, a contractor will most likely have the option of appealing the decision to the relevant Board of Contract Appeals. So if you're working under a Department of Defense contract, you get a T for D. If you want to appeal that termination for default, you would then appeal it to the Armed Services Board of Contract Appeals. If you're dealing with a civilian-based agency, then your appeal of that termination for default would go to the Civilian Board of Contract Appeals. In an alternative, you also have the right to appeal a termination for default directly to the Court of Federal Claims. So as noted in more detail in mine and Megan's recent blog that we just put up, contractors also need to be wary of raising certain defenses to a termination for default. For instance, if you're raising arguments of excusable delay or constructive change, you definitely want to make sure that those arguments were either in a cure notice response or a show cause response to ensure that the arguments were before the contracting officer before appealing them to the board. There's a possibility that you could lose jurisdiction over those arguments if they haven't been before the CO. One way to ensure that they are appropriately before a contracting officer and then appropriately before the board would be to file a certified claim with the contracting officer simultaneously while filing an appeal to the board or Court of Federal Claims, raising the issues of excusable delay or constructive change. So for termination for convenience, the termination for convenience clause, it's often incorporated into a contract. It gives the government the right to terminate a contract regardless of how the contractor performs. So the termination for convenience clause can be invoked if the contracting officer determines that it's in the government's best interest, so long as the government issues the termination for convenience in good faith. So when a contractor is terminated for convenience, the government and the contractor will often negotiate a termination settlement. So we often have clients come to us after a termination for convenience, asking for advice on how to prepare a termination for settlement or termination for convenience settlement proposal. This allows a contractor to recover costs for work that is performed under the contract up to the time of termination. And it often allows a contractor to recover reasonable profit on a portion of the work that was performed prior to termination. When the government and contractor are unable to agree on a termination settlement amount, or if the contractor believes that the termination for convenience was actually entered in bad faith. The government can then issue a unilateral determination as to the costs requested. And then the contracting officer would then have the opportunity to appeal that unilateral determination to the Board of Contract Appeals or to the Court of Federal Claims.
The next thing we're going to talk about is knowing the limits of government authority, and specifically who has the authority to bind the government. The short answer is the contracting officer. And oftentimes we get calls from clients saying, well, the contracting officer's representative or technical representative told us to do X. And if the CO has no idea that this has happened or didn't authorize the action, generally those representatives do not have authority to bind the government or issue instructions. This is a key point that everyone needs to understand, is making sure that whatever direction you are following comes from the contracting officer, or at minimum, the contracting officer is copied on the communications and or followed up with after the fact. Typically, you should look in your contract. There will be a clause explaining who has the authority to bind the government. Generally, it's only the contracting officer. There may be the ability for the contracting officer to delegate this authority to the representative, the technical representative, whatnot. But the key is to look into your contract to see specifically who within the government agency has the ability to bind. If it's not designated in the contract, you should get a separate written letter from the agency specifying who has the authority to bind them. This is very critical as it comes later on. If the government counsel, when they get to either the claim and or the appeal process, looks at their files internally to see who told you to do whatever it is you're saying you were told to do. And if it's not the contracting officer or someone with an ability to bind the government, often their defense is going to be, well, you should have not performed this. And as a contractor, you really just want to please your customer. But make sure that whoever you're pleasing has the authority to bind. Along those lines, the government should be bound when you are given direction by an official who acted within the scope of his or her actual authority. Again, it needs to be actual authority, not apparent authority. So again, look to your contract to see who has the actual authority to do so. There is an argument regarding implied actual authority, which could arise when maybe in one instance, the government intended to grant authority in writing but failed to do so. Or the contracting officer was copied on all of the communications such that he or she should have known the direction that was given to you as the contractor or knew the facts that were going on, such that he or she would not be able to come back later on and say, I had no idea that this was going on. Ideally, the communications will be directly with the contracting officer, but we recognize that oftentimes the contracting officer is not the individual on the ground or giving the work or direction. Although they should be, you should confirm with the contracting officer before you do anything, if at all possible. Or at minimum follow up after saying, on such and such date, I was told to do this, we did this, here's the result of that. Just so that you have a record of those communications if and when you need to file an REA or claim to explain that the authorized official, most likely the contracting officer, was aware of what was going on and ratified whatever action that you took.
So moving on to the government's duty to cooperate, this is often an argument that we make in a request for equitable adjustment or a certified claim to the contracting officer. The implied covenant of good faith and fair dealing, it's actually a common law principle that suggests that every contract imposes upon each party a duty to cooperate in good faith and deal with each other fairly. This is also applicable to federal government contracts as well as commercial contracts. The Board of Contract Appeals and the Court of Federal Claims have long held that each contracting party has an affirmative legal obligation not to hinder performance or prevent the other party from obtaining what they term the fruits of their bargain. In accordance with this, the government has a duty to cooperate with all aspects of a contract. When the government does something that's on its face suggests underhanded activity, this is where an implied duty to cooperate argument would come in. For example, if a government was refusing to open gates or failed to approve an individual security clearance, this would directly impact your performance capabilities. So you may have a claim to make that they are failing to cooperate. This is often heavily dependent on documentation of performance and interactions with the CEO or members of the government. So you want to ensure that you have a supporting record if making this argument. One other thing to note is that bad faith right now is not an element of a breach of the implied duty of good faith and fair dealing. If we were to argue bad faith, the standard is extremely high and can often be hard to prove. We've heard murmurs that DOJ is pushing to try to add this as an element to the implied duty of good faith and fair dealing argument. Presently, that has not happened, but we just want people to be aware that that's a possibility. Another thing that we often try to remind our clients is making sure when executing modifications that you're not waiving or releasing any of your rights. Contractors often need to be extremely wary of any waiver language prior to executing any type of change or modification to their contract when working with the government. The government will often try to include any type of waiver language in a contract mod that would release them from any liability for any action or inaction prior to the execution of the modification or the change. It's also important to note that waivers and releases of rights can be an absolute bar to recovery of costs under the contract. So oftentimes we'll have a client come to us and they'll want to raise an argument of excusable delay, and then we'll take a look at a modification that they executed 2 months prior to the close of performance, and they'll have had released all rights prior to that modification. So that would limit any amount of excusable delay argument that they would try to make to extend the performance period. If the release language is unambiguous, a contractor is more than likely stuck with the plain and ordinary meaning of that release. Our best advice is if you think there's a possibility of a claim or an REA, that you make sure to reserve your rights to raise it later. Keep in mind that you have 6 years to file a certified claim with a contracting officer. So you definitely want to make sure that you protect your rights to do so before executing any type of change or modification. Another thing that we often recommend to our clients when they come to us in preparation of an REA or a claim is the use or engagement of an expert or a consultant. One of the reasons why we think they can be very helpful is they can, so for instance, if you were working on a construction project and you ran into inspection issues, or one issue that we did run into is we had a government that was overzealous as far as a concrete inspection. So we recommended the engagement of a concrete expert to supplement our REA and then claim with a concrete expert report. By supplementing a claim or an REA with an expert report, the government's often more inclined to resolve it at that level and negotiate settlement. It just makes your arguments a little bit stronger by having an independent third party support your claim for recovery. One thing that we do like to note is that the engagement of an expert or consultant can be costly. So the use of one is often dependent on an anticipated cost recovery. So if your cost is pretty low that you're trying to recover on an REA or a claim, it may not be worth moving forward with an expert. It's really dependent on a case-by-case scenario. Another example, like if you were dealing with a differing site interpretation of a design spec, it may be worth getting an independent third-party engineer to provide a report to support your findings and adding it to your claim package. Oftentimes, like I said, it can persuade a CO to resolve the dispute at that level. If you are certifying, one important thing to note, that if you're certifying a claim higher than $100,000, it's really good to have an expert ensure that your figures are accurate if the damages argument is more complex.
Another thing to add to that too, Lauren alluded to this, is if you do use an expert at the outset, it can save time and headache later on when maybe you do get to litigation and then you hire an expert. And when they go through your calculations, they realize that maybe what you're entitled to isn't as high as what you think it is. It can help alleviate some of that stress later on. The next item that we would like to touch on is subcontractor claims. We mentioned at the beginning that a subcontractor claim is different, primarily because the subcontractor is not able to submit its own claim to the government. The subcontractor doesn't have a contract with the government. They only have a contract with the prime contractor, who must agree clearly and affirmatively to sponsor the subcontractor's claim. Generally, you can submit an REA or a claim as long as the prime contractor agrees to sponsor it. FAR 44.203C does allow the subcontractor the right of an indirect appeal. But something to keep in mind, really, whether you're the prime or a subcontractor, is that right or the obligation of the prime contractor to sponsor a subcontractor's claim should be fleshed out in the subcontract itself. There was one case a few years ago in Binghamton regarding an appeal, which was a subcontractor's claim, but the appeal was dismissed because the subcontractor did not ask and the prime contractor did not agree specifically to sponsor the claim. While the subcontract spoke to this generally, stating that there is a right to appeal, it did not bind the prime contractor to sponsor the appeal. And because the subcontractor didn't ask and there wasn't an express sponsorship, the appeal was dismissed. Again, the sponsorship regarding a subcontractor's claim really should be in the subcontract agreement. Depending on whether you're the prime or the subcontractor, the language that you include in your subcontract may be different. Simply just including boilerplate language that gives the subcontractor a right to take over a claim or file an appeal doesn't necessarily mean that the prime contractor has specifically agreed to sponsor a particular claim. So if you are a subcontractor, you really want to pay attention to this language in your subcontract, and if you're a prime contractor, regarding the requirements of the prime to sponsor a claim. And even if your subcontract doesn't speak to it specifically, or even if it does, you should get the sponsorship of the claim or the appeal in writing from the prime contractor, just in case there's any question of whether the claim should or appeal should be sponsored down the road.
Okay, so now we're going to touch on an overview of the claims appeal process. So after the contractor submits a claim, the contracting officer must either resolve the claim within 60 days from receipt, and I know I touched on this earlier. I think it's important to just run through it really quickly, or the contracting officer has to notify the contractor of the date by which the contracting officer is going to issue the decision. Once the written decision comes down, the contracting officer has some options. So the first option would be to take it to the Board of Contract Appeals, and that's either the Armed Services or Civilian Board of Contract Appeals. The other option would be to take the appeal of the claim to the Court of Federal Claims. The election doctrine does apply, so whatever you choose, you're then bound by that forum decision. So you cannot appeal to the Armed Services Board, get a negative decision, and then try to appeal to the Court of Federal Claims. It's one or the other. But one thing that can be done is both BCA and COFC decisions can then be further appealed to the U.S. Court of Appeals for the Federal Circuit. So if a contractor is unsatisfied with the contracting officer's decision, the contractor may appeal the decision to the appropriate Board of Contract Appeals within 90 days of receipt of the decision. As compared to the Court of Federal Claims, an appeal to a BCA is often a little less formal and less costly for our clients. For instance, there's no fee to take an appeal to a Board of Contract Appeals. All that is required is a written notice of appeal, which can then be sent via email to the appropriate board's recorder or clerk. Once that notice of appeal is received by the clerk, the BCA will then docket the case and send a docketing notice to the parties. The contractor's complaint would then be due within 30 days of the notice of the docketing of the appeal. Under the rules, the government then has 30 days to answer after being served with the complaint. And then the government will be creating what's called a Rule 4 file. So the Rule 4 file consists of all relevant documents that are in the government's possession that are relevant to the appeal at issue. One good thing about the boards is that they have what's called a small claims procedure, and this is available for claims that are of $50,000 or less for small business concerns. The appellant, if they want to elect that procedure, they have to do it no later than 30 days after receipt of the agency's answer. And then the presiding judge has to resolve the appeal within 120 calendar days. As another option is an accelerated procedure for claims of $100,000 or less. And for this, the appellant also has to make an election for this procedure no later than 30 days after receipt of the agency's answer. For this process, the board has to resolve the appeal within 180 calendar days. As far as the other forum option, which is the Court of Federal Claims, there's less of a rush as far as appealing the contracting officer's final decision. If you're taking it to the Court of Federal Claims, instead of having a 90-day window, you now have a year. Once that is filed, the government will then have 60 days to answer after being served with a complaint. Obviously, this is more of a formal forum and can often be more costly for our clients due to the formalities. Another difference between appealing to the boards and the Court of Federal Claims is that you're no longer dealing directly with agency counsel and opposition. Once an appeal is filed with the Court of Federal Claims, a DOJ attorney will be appointed to represent the agency, and they will take over the case as lead counsel. Oftentimes, the 60 days to answer will be extended because it can often take the DOJ attorney a little bit more time to get up to date on the facts. Under the rules, though, the parties can also request an expedited trial schedule through a joint preliminary status report, which is available under the rules of the Court of Federal Claims. This expedited procedure is often appropriate when discovery can be completed within a 90-day period. A case can be tried within 3 days. There's no dispositive motions such as motions to dismiss or motions for summary judgment. And the parties are seeking a bench trial, which means that only the judge will be presiding over the dispute.
And the last thing we are going to touch on is ADR, Alternative Dispute Resolution. It is available at both the boards of contract appeals, the Court of Federal Claims, as well as some agencies. It's a tool to use if you aren't really looking to go to trial or go all the way through the appeal to a decision. You can use mediation or other methods such as arbitration, binding, non-binding. You can use it before or after the contracting officer's final decision. So if you submit your claim, you haven't got a decision, but the agency is really willing, you could see if the agency is willing to work with you through ADR to arrive at some resolution that could be mutually agreeable between you and the government. You can also use it after you file the appeal. Some board judges will ask that you will encourage that you use ADR if it sees that maybe this could be resolved without the need to go to a final decision. It's possible that you could do it prior to filing an appeal, whether you could go to the board and kind of ask for ADR at that point. It is voluntary, so both sides must agree to participate. I mean, while the board or court could recommend it, generally both sides need to agree. At the Court of Federal Claims, the judge can do it, or you can have a neutral party through mediation. You can have a mini trial. There's lots of different ways and forms that ADR could take place. At the boards, it's similar. You could have mediation, mini trial, non-binding. You could ask for an advisory opinion, or you could have a binding arbitration, kind of depending on what the sides are willing to agree to. But it is a method that is used pretty frequently when either you are in the appeal or right before getting to that necessary stage. So while appeals, it's a way to reduce costs somewhat and to try to arrive at a resolution faster, because appeals can be timely and costly. So depending on the circumstances, you may be able to use ADR, and that's something that we could definitely just talk to you about. It looks like we have a few minutes left, and that we've received a couple of questions. Let us go through it and see if we can answer these now. One question is, can REAs or claims include costs that have not yet been incurred? Generally, you should be submitting an REA or claim with supporting documentation to back up your cost. And particularly for a claim, it needs to be some certain. So you need to have hard evidence as to the facts, as to the figures that you're asking for. So you wouldn't be able to ask for potential future costs. It needs to be a set figure with supporting documentation. As the REA or claim goes on, you can always try to send an amendment to the REA or claim saying, well, our costs have increased, so we're going to add these additional costs to our REA or claim. So that's something that a tool that you could use for future costs if you're
Right, and to speak to that fact as well, if you say you file a claim to a sum certain and then you try to appeal it to the board, there is an argument to be made under the enlarged claim doctrine. If certain costs are incurred after you filed your claim, there's a possibility if the costs stem from the same operative facts that were represented in your claim, you can then enlarge your cost recovery on appeal. Somebody did ask whether the webinar slides and recording will be available to participants later, and they will be. We'll make sure that those go out to all registered so that they can access them after the end of the webinar.
And if you have any additional questions or follow-up that you have after the webinar is over, feel free to email Lauren and/or I, and we will try to get back to you in a timely manner.